We're now moving from meetings to that next stool leg, the Public Record Act. And an unknown author commented, "Why would you pay money to have your family tree traced? Go into politics and your opponents will do it for you." Like meetings, records are broadly defined. Records mean just about anything. Paper, correspondence, completed forms. Doesn't matter what shape it's in, what media it's in. One of the difficult issues that many of us in our communities are facing is we have records on old media, microfiche or Foran, or some weird stuff that we haven't been using for decades. There is some authority that we don't like to recognize, but it's out there and can be argued against you, that you not only have to maintain the record in its original media, but you have to maintain the equipment to view it in its original context. We frankly disagree with that, but just be aware that it's out there. Before you destroy any piece of equipment, be sure you're not going to need it sometime in the future. You have a specific obligation to retain records. And if you, as a council member, as we'll talk about, are maintaining records on a personal computer or a business computer, you may be holding public records as well, and you also have a retention requirement regarding those records, notwithstanding the fact that the council or clerk may have a copy of that record. In a recent City of Shoreline case, a council member received an email regarding a piece of city business. The council member forwarded the email on to other city council members, then deleted the original email and deleted it completely off of her system. Another council member at a council meeting raised the subject of this email. We recently received an email from a citizen that said something or another. Somebody in the audience said, "Oh, well, I'd like to see that email, and I'd also like to see the entire chain of email where it came from." And our Supreme Court said that not only are you entitled to the email itself, you're entitled to the metadata. Some of you may not have ever heard the term metadata, but metadata is that record of where an electronic transmission has been, where it originated, to whom it went, and where it's gone. And that kind of information is a public record as well. So don't think that if you've saved a hard copy that you're not exposed with respect to the electronic version of that particular record. No reason is necessary for a request for public records. We know in our business that records are requested in many cases simply to harass. We also know, because of a number of prisoner cases, that there are people out there who make constant public records requests, hoping that the government will screw up and they'll get a fine or a penalty, for the failure of government to respond promptly to the request for public records. And of course, we do deal with the legitimate requests by many, many people, but our law doesn't distinguish among the requests for records, and we must be responsive in all cases to them. There's no particular form of request required. It can be written down on the back of an envelope. It can be put on the city's form that you make available. It can be an email text to you or to the city clerk. Some have, I've heard say, well, they have to come in and pay for it. No, they don't. You don't have to pay to see a public record. You have to pay if you want a copy of the public record. You don't have to pay to see the public record. Your job is to make it available for review and then to provide a facility or to provide for copies at your cost should that happen. Do you get to charge the requester for search time? No, you don't. And some of you have heard about the dramatic cases in small Mesa or Gold Bar up in Snohomish County where the public records issues have nearly bankrupted those communities because they're spending more and more of their time responding to Public Records Act requests. Again, we have a strong mandate in this state for public records and disclosure, but it is a burden, and you know that there is some legislation being proposed to address some of these cases. Prisoner cases have been addressed. The legislature stepped in and actually has provided a different mechanism for limiting prisoner requests for public records. Email. Anybody recognize this photograph? Photograph of the Evergreen State Fairgrounds in Monroe, Washington. And that Monroe was the site of a significant case in which a request was made to the city of emails and communications on city council members' personal laptops and or business computers that related to city government. And the court in that case reminded us all that we have the burden, not the requester, to prove that the public record does not exist or that the refusal to produce the public record is consistent with the law. And in that particular case, finding was that the council members had to turn over the information on their personal or private computers. For those of you here or in our satellite offices who have not yet taken office, I urge you to not use your personal or office computers for any kind of city business. Many of you cannot afford to do this, but the better tool is for each of you to have your own web address at the city where emails and communications can go to you and the city can better track those records. What about tweets what about text messages? They are as much recoverable as just about anything. The difficulty, of course, with tweets and with texts is that where is the record of them? The answer is they are not held by you or the city. That record only exists with the phone company or the cable company or the satellite provider who's providing that service to you, Google or whatever system you happen to be using. But, for example, if you have a series of tweets or texts about something to do with city business, and you're, again, after you've taken office as a council member, and a request comes in for such information, by destroying that information after you've learned a request has been made, you've probably violated the Public Records Act because you haven't retained a record accordingly. You've got to really be careful about this, folks, because it's an emerging issue that could really come back to haunt you. City Council here in the city of Olympia got in trouble because they were sitting in council meetings texting back and forth about how loony those people were who were speaking at the city council meeting. And, you know, somebody saw that they were, fingers were busy doing something during the council meeting and sought to have copies of all of those texts that were going back and forth among the council members. Here's some hints. Oh, I forgot to mention a particular email decision. This just came out of the Kitsap County Superior Court in a case involving Bainbridge Island City Council member emails, and the court ordered the production even though the city said they're not our emails, they're on the personal computers, the courts are going to order your hard drives seized and searched by forensic people to look for documents that relate to city business. There remain First Amendment and privacy issues out there for you as a council member regarding how can they get to your hard drive, but nevertheless, it is an issue, and that's why I urge you not to do city business on personal computers. Before sending an email, ask whether you would like to see the email on the front page of the local paper, because that's where it might end up. Limit email chains to those who really need to see them. Now, you may think one of your friends or neighbors is going to be supportive, but there are so many cases where they forward it on, and pretty soon you've lost control, and it's going to come back to get you. There's opinion or expressed about a particular policy or issue, you might want to check with the city attorney first. If they're preliminary materials, preliminary reports, drafts before any decision has been made, mark them draft so that people recognize that the deliberative process exemption might apply. The deliberative process exemption says preliminary materials before a decision is made aren't subject to disclosure. Notwithstanding the Public Records Act, also remember that even if it's not recoverable under the Public Records Act, most of it could be recovered through the litigation process. And if you're involved as a council member, or your city is involved, your documents might be recoverable in civil litigation. I mentioned this earlier. Adhere to the city's regular document retention policies. You don't necessarily know what those are today, but your clerk does, and the clerk will provide you with whatever information you may need with respect to maintaining a record. As an example, those emails that you might get regarding scheduling, for example, the Association of Washington Cities training, or in January after you've taken office, there's an email regarding the legislative conference or an upcoming council meeting. Those kinds of records under almost every record retention policy can be destroyed immediately. They're just scheduling, they're procedural, they're not important. But there are some public records that can never be destroyed. A common example of that is a city ordinance. Now, you wouldn't have the original in your files, but the city clerk will not be able to destroy a city ordinance or a document relating to property. Disposition, disposal of property can only be done pursuant to an approved record retention and destruction schedule. The default, if you were wondering if you don't have one in your community, is that program that has been developed by the state archivist together with the State Public Records Committee. I do want to comment, and this goes back to the public hearing issue a little bit, public hearing versus public comment. The Public Records Act applies to records. It may be trite to say that, but it's in fact the case. The Public Records Act does not require a city to produce information. It requires a city to produce its records. A good example of this might be when someone comes into the planning department and says, well, what can I build in this area of the city? How high can I build and what kind of uses? Nobody at the city has an obligation to tell that person anything. They can hand them the zoning code and say, here. Well, of course, that's not the way we do business. We want to be helpful to the citizens in the community. But just as a caution, you don't have a legal obligation to provide information, only the legal requirement to provide records. Here's a case that came out of the city of Seattle. A guy by the name of Bonamy sent an email to the city requesting something, and when the city didn't respond promptly, he said, aha, gotcha, because you didn't respond within 5 business days, and sued the city seeking penalties. Well, the court looked at this and noted in a common sense fashion that a distinction must be drawn between a request for information about public records and a request for the records themselves. the law, the Public Records Act, does not require agencies to research or explain public records, but only to make those records accessible to the public. Nor does the Act require public agencies to be mind readers. It's nice when the courts actually say something that has some common sense to it. A public agency cannot be expected to disclose records that have not yet been requested. To hold otherwise would place public agencies in an untenable position. That's a 1998 decision by our courts involving a public records request that really wasn't a public records request.